2018, replacing Ronald Young for a term to end on the 18th of July, 2018. He was then reappointed and confirmed in 2018 for a term to end July 18th, 2021. Following a 180-day holdover period, his term expired on or about the 14th of January of this year, 2022. This is the first time that the mayor has nominated a chairperson of the commission for approval through the council process. Previously, the mayor designated the chairperson from among the confirmed commissioners. The Rental Housing Commission is a 3-member independent quasi-judicial body that holds an appellate hearing on appeals from the rent administrator or the Office of Administrative Hearings regarding disputes concerning the district's rent control laws. The commission is part of the executive branch of the district government. The 3 commissioners are appointed by the mayor with the advice and consent of the council. One of the commissioners is designated the chairperson of the commission, and each commissioner must be a member in good standing of the District of Columbia Bar. The commission has 3 statutory functions designed to preserve and increase the supply of quality, affordable rental housing for the residents of the district. First, the commission issues, amends, and rescinds regulations that are promulgated for enforcement of the Rental Housing Act of 1985. Second, the commission certifies and publishes the annual adjustment of general applicability to rents based upon annual charges to the Consumer Price Index, CPI, as we've commonly referred to it, for the District of Columbia area. This certification is typically published in early May. Third, the commission decides appeals brought to the commission from the Office of Administrative Hearings and, of course, the rent administrator. The Rental Housing Commission plays a vital role in adjudicating the district's rental housing laws. During Mr. Spencer's tenure on the commission, he has overseen several vital developments at the commission. Most notably, under his tenure, the commission has become a fully independent agency, having severed its administrative and budgetary ties with the Department of Housing and Community Development. Over the past several years, the commission has published a final rulemaking governing the implementation of the district's rental housing rules and regulations, the first change to those rules in 35 years. The commission is, for the first time, acting truly independently. It has implemented an annual planning process and evaluates its performance and the performance of its employees independently according to high quality standards. As of tomorrow, the 17th of February 2022, the commission will not have the quorum of commissioners that is required in order to hear and decide cases, promulgate rules, or exercise any other power. As mentioned earlier, Mr. Spencer's term on the commission expired July 18th, 2022, and his holdover period expired January 14th, 2022. And Commissioner Ranga Puttaganta was nominated by President Biden, and on February the 2nd, 2022, finally confirmed by the U.S. Senate to be an associate judge on the D.C. Superior Court. Her last day with the commission will be on February 17th, 2022. This will leave Commissioner Lisa Gregory, who was last confirmed on December 15, 2020, for a term that will end on July 18, 2023. She will be then the only commissioner serving on this important commission. With several critical decisions looming for the commission, including the adjustment to allowable rent increases for rent control properties, it is critical that the role of the chairman be filled. I look forward to a full conversation with Mr. Spencer And I know I will be joined by colleagues. In fact, I see Councilmember Silverman already is with the committee on this important issue. So with that said, I will now turn to my colleague, Councilmember Silverman, who may want to make opening remarks, and then we will move to our public witnesses, and then, of course, to having an opportunity to hear from Mr. Spencer. So, Councilmember Silverman, you're on. And good morning.
Thank you so much. Good morning, Councilmember Bonds, and good morning, Mr. Spencer, and to other colleagues on the council who might be watching, and today's witnesses and the public, of course. I didn't quite transition to the office yet, Councilmember Bonds, so I'm at home, which I know is an unusual place for me to be with hearings, but this is a bright and early one. So I'm here, as you noted, Councilmember Bonds. I'm a member of the Housing Committee, and I'm also chair of the Labor Committee, as you know. And I'm wearing actually both hats today. So as you noted in your opening, the position of Rental Housing Commission Chair is an important one. It is responsible for making important decisions about our rental housing, as well as the chair is the personnel authority for the agency and charged with developing its code of professional responsibility. The Rental Housing Commission is a small agency, and sometimes we tend to overlook or not look as closely at small agencies, but actually I want to thank you very much, Councilmember Bonds, for this hearing. I do think it's an important agency, and having a hearing like this ensures that the council is taking a good look at its operations. As you noted, the Rental Housing Commission is the body charged with writing regulations under the Rental Housing Act and deciding appeals on rental housing issues that came before the Rent Administrator or Office of Administrative Hearings. So we need to make sure that the work is done well and efficiently, and that district renters and rental property owners can get both a high level of attention to detail and a commitment doing this work in as timely a manner as possible. So I say that because I'll be frank, I am concerned about some red flags that have been waved about the management and operations of the commission. Again, I want to thank you, Councilmember Bonds, for the opportunity to explore these issues. I think a hearing is the proper venue for this. And I think it gives a chance both to explore these issues as well as to give a chance to Mr. Spencer to address them. So let me say what I mean about the red flags. So first, there is a complaint stemming from a former employee's Family and Medical Leave Act request that recently settled for $400,000. The Office of Employee Appeals previously ruled for that same employee and overturned a suspension that was issued by Mr. Spencer. So I am going to ask about this, Mr. Spencer's take on it. So that involves the role of the chair as personnel authority. I also have concerns about operations. So in last year's performance oversight responses, Mr. Spencer testified that it took an average of nearly a year to issue a decision. And certainly I understand that appeals can be complicated, but I think this is an unreasonable amount of time and too long for decisions to be made. When I asked Mr. Spencer about the agency's stated goal to issue decisions within 45 days of a hearing, a month and a half, all I heard was that a year is more realistic for deciding an appeal and 45-day goal. Once again, I just think we need to be reasonable about the amount of time it takes to make a decision. If 45 days is unrealistic, I do think 365 days is also unrealistic. Let's see. I'll leave it there, Councilmember Bonds. So I will be asking Mr. Spencer questions both about his role as personnel authority and about operations of the commission. And I thank you again for the opportunity to do that today.
Thank you very much for your comments. And as chair of this committee, those are issues that I too am concerned with. And we did query about a couple of those things to be direct. And so I'm expecting that Mr. Spencer will have some updated information for us today. Thank you very much. We'll now move to our public witness. I believe, yes, we have one public witness, Ms. Sherry Acosta.
She should be joining as a panelist momentarily.
All righty, thank you.
Okay, she's here now.
All righty, thank you. Ms. Acosta,
Good morning.
good morning.
I don't see my picture, but I see my name. Can you hear me?
Yes, we can hear you.
Okay, unsure why I don't have a picture. Camera's on and working.
I don't know, but we'll take your testimony.
Very good. Thank you.
Mhm.
Perhaps my picture will come on while I'm speaking. Okay. Well, first of all, I want to thank the committee for allowing me to present my testimony. Good morning to everyone. And I appreciate this opportunity to appear before you this morning regarding this important matter. My name is Sherry Acosta, and I am a former District of Columbia government employee. I am now 63 years old and a single mother and grandmother. I provide assistance and support to my adult daughter, and I am a caregiver for my granddaughter, who is now 7 years old. I am currently unemployed after I was terminated in May of 2020 by my former supervisor, Michael Spencer, after I filed multiple employment discrimination and retaliation complaints against him due to the disparate treatment that I experienced while working under his direct supervision at the DC Rental Housing Commission. I was employed by the District of Columbia government, the district, in July of 2001, and I remained employed for more than 18 years as a dedicated employee and public servant. I have received awards and commendations during my tenure as a staff assistant, including an Outstanding Customer Service Award from former Mayor Anthony Williams, DH City Employee of the Month, and numerous outstanding performance appraisals during my lengthy career with the DC government. I also received numerous compliments and praise from many constituents, coworkers, former managers throughout the tenure of my 18 years of employment. My successful career was abruptly taken away from me when I was terminated on May 7th, 2020 by my then supervisor, Michael Spencer, at the commission in what I would characterize as a final act of blatant retaliation after I'd filed my multiple discrimination and retaliation complaints against him. I am here today to testify before your committee in response to the proposed nomination for Mr. Spencer to be reappointed to the important position of Chairman and Chief Administrative Judge at the DC Rental Housing Commission. To provide you with some brief background information, I did start my employment with the district at the DC Office of Human Rights as an intake officer in 2001, writing discrimination complaints. And I transferred to work to the DC Department of Housing and Community Development, DHCD, in 2002. I was instructed informally through an interoffice email from a DHCD management official that I was to report to work at the commission in 2011 under the supervision of former Commission Chairman Peter Segedy-Mazak. The commission at that time was still considered part of DHCD, but it was located at a different address, separate and apart from DHCD's offices. No official SF-50 form was ever processed by DHCD, DCHR, or the Rental Housing Commission to formally make my work assignment at the commission an official transfer. I am providing the following statements regarding Mr. Spencer's actions at the DC Rental Housing Commission based on my personal work experience and observations while I was at the commission. And I will say that I am exercising my First Amendment rights in providing this testimony to the committee. I believe that this information needs to be fully disclosed to the citizens of the District of Columbia, whose hard-earned tax dollars fully support the budget of the DC Rental Housing Commission, which, as you know, utilizes only local funding. Additional and more detailed comments regarding my concerns about the Rental Housing Commission and the actions of Mr. Spencer were memorialized in a letter dated February 1, 2020, which I sent as an attachment with supporting documentation via several emails to a council member and Housing Committee Chairperson, Anita Bonds, following an in-person discussion that we had on January 30th, 2020. As your committee is aware, Mr. Spencer was appointed to the DC Rental Housing Commission, which I've defined herein as the commission or the RHC, as a commissioner in July 2016. In 2017, I was required by my former commission manager, Mr. Segedy Mazak, to file an internal commission complaint against Mr. Spencer after Mr. Spencer required that I meet with him in the commission's conference room on July 30th, 2017. I had come into the RHC office briefly on that day while on approved leave, only to drop off paperwork at the RHC office. And I had my then 2.5-year-old granddaughter with me when I stopped by the RHC office. After Mr. Spencer asked me to come into the conference room, he then proceeded to berate me in the presence of my granddaughter, which upset me and frightened my granddaughter. After I submitted my complaint regarding Mr. Spencer's actions on that day, at the request of Mr. Segedy Mazak, Mr. Spencer was extremely irate, and his attitude and behavior whenever he was around me became progressively worse. Mr. Spencer later intensified his harassment, bullying, and retaliation of me after he was appointed by Mayor Bowser to become chairman of the RHC in October 2017, replacing Mr. Segedy Mazak and becoming my immediate supervisor. His retaliatory actions against me included issuing me 2 letters of admonition, placing me on a 90-day leave restriction, issuing me an advance notice of proposed 9-day suspension, proposed 8-day suspension, and a 5-day suspension, and placing me on a performance improvement plan, all in 2018. It is my firm belief that all of these actions were filed against me in retaliation after I filed my complaint at the request of Mr. Segedy Mazak regarding Mr. Spencer's treatment of me and my granddaughter in the commission's conference room on June 30th, 2017. I also filed employment discrimination and retaliation complaints with the DC Office of Human Rights, OHR, against Mr. Spencer after his bullying, harassment, and retaliatory treatment escalated further. Exit letters and notices of right to file a formal complaint with OHR were issued on December 19th, 2017, which was the original letter, and January 26, 2018, a revised letter by Jody Harrington, who was my EEOC counselor and is currently also an attorney at Office of Procurements, I believe. In July 2018, I was detailed back, detailed back to my main agency headquarters, the DC Department of Housing and Community Development in the Development Finance Division at 1800 Martin Luther King Jr. Avenue Southeast, after I removed my complaint from the jurisdiction of OHR and refiled my employment discrimination complaint against Mr. Spencer and the district in DC Superior Court on July 13, 2018, when his treatment of me in the hostile workplace became unbearable. I was returned back to the commission on September 30th, 2019, at the direction of a memo that I received from former DHCD Deputy Director Allison Ladd in July 2019, which was just a few months before the DC Council passed legislation to make the commission an independent DC government agency, no longer part of DHCD. Upon my return in September 2019, Mr. Spencer immediately changed the start time for my tour of duty to 8:15 a.m., which was before the commission opened for business in the morning. and which was a time that severely interfered with my child caregiver responsibilities in the morning with my young granddaughter. Mr. Spencer also immediately took inappropriate action upon my return to the commission in September 2019 to remove me from the union, AFGE Local 2725, which ultimately enabled him to issue an advance notice of termination on February 21, 2020. I was the only commission support staff member who was removed from union membership. Mr. Spencer stated that the reason for my being removed from union membership after I returned to the commission in September 2019 was because he was going to have me do collective bargaining unit negotiations with the union, a task which I had never performed at any time, either before or after the removal from union membership, and for which I had no training or special skills that would have enabled me to perform such a task. Without any authorization or official permission, on January 17, 2018, Mr. Spencer made changes to my 2016-2017 historical performance evaluation, which was an official DC government document. In 2016-2017, my performance evaluation was conducted by former chairman of the commission, Peter Segedy-Mazak, my supervisor of record during that review period. Unbeknownst to Chairman Segedy-Mazak or me, Mr. Spencer gained access to the final 2016-2017 performance document in the DHCD PeopleSoft system on January 17, 2018, after I had filed discrimination complaints against him. Excuse me. Mr. Spencer altered and downgraded the positive comments that Chairman Segedy-Mazak had provided in my historical performance evaluation, causing anyone viewing my performance reviews in PeopleSoft to reasonably rely upon Mr. Spencer's unauthorized false statements as true. The DC Department of Housing and Community Development and the DC Office of Human Resources have both acknowledged in writing that Mr. Spencer was not authorized to alter my FY 2017 performance eval that had been prepared by my manager of record for the review period, Mr. Segedy-Mazak. Mr. Spencer revised my position description when he removed me from union membership and protection. He demoted me from a staff assistant grade 11, step 10, to a grade 11, step 0, and listed my job as legal and not career service. He also assigned me the task of assisting with drafting commission decisions, work that was above my pay grade and was not appropriate for a non-lawyer staff assistant without specialized legal training. On November 15, 2019, Mr. Spencer suspended me for 20 days without pay for retaliatory reasons. And on December 30th, 2019, he placed me on another performance improvement plan. I appealed the 20-day suspension to the DC Office of Employee Appeals, and a 2-day hearing was held on the matter before OEA Judge Arian Cannon on November 4 and 5, 2020. On February 25th, 2021, Judge Cannon reversed all of the alleged charges that Mr. Spencer had made against me in the 20-day suspension, and Judge Cannon initially ordered the commission to reimburse me for back pay and lost benefits that I had incurred as a result of the 20-day suspension. On November 22nd, 2019, while I was not at work due to the 20-day suspension without pay, Mr. Spencer sent me another, quote, counseling memo, quote, via email. Mr. Spencer's email and attached memo to me on that date inappropriately contained 2 footnotes at the bottom of the first page, which contained graphic descriptions of rape and sexual assault. According to his, quote, counseling memo, attached to his, quote, counseling memo were approximately 17 pages of scanned articles about R. Kelly, 17 pages of scanned articles about Bill Cosby, and 47 scanned pages of articles about Harvey Weinstein. I felt very intimidated and concerned by the content of this very bizarre and inappropriate communication from Mr. Spencer, which I had to read from home while I was not on official work time. On January 22nd, 2020, Mr. Spencer sent me a notification that required that I undergo medical and psychiatric fitness for duty examinations for unsubstantiated reasons. After I successfully passed both medical examinations, Mr. Spencer obtained copies of my confidential medical records pertaining to the exams from the professionals who performed the examinations. And he distributed those records to several other district government individuals. He took this action without obtaining my consent or any signed release form from me to release my confidential medical information. Mr. Spencer's written forms of disciplinary action against me were so detailed and voluminous that it was apparent to me that he had little or no time to do the work of the commission. The commission's key performance indicators suffered under Mr. Spencer's leadership, as evidenced by the performance results that he has reported to your committee over the past several years. It is my opinion, from my personal observation and experiences, that Mr. Spencer wasted hours and hours of government time and resources and spent more time harassing and disciplining me than doing the business of the commission and the District of Columbia. He also involved many members of the commission staff, including a government contractor, another commission judge, and a commission lawyer in his retaliation and harassment campaign against me. As evidenced by his lackluster performance numbers, it is my conclusion that Mr. Spencer was not concentrated on addressing the rental housing related needs and concerns of the citizens of the District of Columbia. Instead, he focused the majority of his working hours composing and sending hundreds of emails and related documents to me. And he sent those emails to me on a daily basis. From the time that his chairmanship began until he terminated me for my 18 years of dedicated public service in May of 2020, I had received more than 800 harassing emails with hundreds of pages of attachments from Mr. Spencer. On February 21, 2020, Mr. Spencer issued me an advance notice of a proposed termination. Mr. Spencer was both the proposing official and the deciding official in the termination action. Of particular note in the termination documents from Mr. Spencer was language specifically imposing discipline on me because of my protected testimony regarding his actions, which I had given in a DC Superior Court hearing in connection with my complaints against him. And I have put in parentheses, disciplining an employee due to their protected testimony in a court proceeding is an action that is prohibited by law. My termination was finalized on May 7, 2020 by Mr. Spencer after he denied my attorney's request for a hearing to be held in front of a hearing officer regarding the proposed termination, thereby ending my 18 plus years as a dedicated public servant for the District of Columbia government. On January 31st, 2022, my attorney, David Branch, sent an email to all DC council members stating the following. And if you would like me to read it, I can. If both of you have read it, it's a paragraph, and I will omit that to save time. I was wondering if both council members have read it. I guess I'll just go ahead and read it into the record. This firm represents Sherry Acosta, a former DC Rental Housing Commission employee with 18 years of employment with the District of Columbia, who was terminated by Rental Housing Commission Chairman Michael Spencer in May 2020. We understand that, and by the way, this was dated January 31st. We understand that the council is scheduled to vote on February 1, 2022 on emergency legislation at the request of the mayor to reappoint Michael Spencer as the chairman of the Rental Housing Commission. Ms. Acosta intended to testify at the hearing, but now will not have an opportunity to do so. We believe that the council and the citizens of the District of Columbia have the right to know that the District of Columbia was sued in federal court in DC based on the actions of Mr. Spencer in terminating Ms. Acosta, parentheses amended complaint attached. The DC Office of Employee Appeals reversed a 20-day suspension Mr. Spencer imposed on Ms. Acosta, decision attached. And the DC Office of Attorney General negotiated, prepared, and entered into the attached settlement agreement with Ms. Acosta to pay her $400,000 to settle all claims based on the actions of Mr. Spencer after he terminated her employment, and the settlement agreement was attached. The three documents that were attached to Mr. Branch's email were, as referenced above, the amended complaint filed in the U.S. District Court for District of Columbia, DC Office of Employee Appeals decision reversing the 20-day suspension, and the $400,000 settlement agreement entered into with the DC Office of Attorney General. These three documents provide a very clear picture of the type of severe harassment, retaliation, bullying, and abuse that I was subjected to by Mr. Spencer during the entire time he was supervising me until he achieved what I perceived to be his ultimate goal, terminating me in retaliation from my 18 plus years as a dedicated public servant with the DC government. After Mr. Branch's email was sent to the DC council members on January 31st, 2022, on the following day, February 1st, Councilmember Bonds withdrew the emergency proposals, PR 24-572 and PR 24-575, for Mr. Spencer's renomination from council consideration and vote during their full legislative meeting on that date. I would further add that I just discovered on Tuesday, February 15th, that the Rental Housing Commission provided a misleading and false response on their FY22 document in response to the Housing Committee's Performance Oversight Pre-Hearing Questionnaire. In their RHC's response to question 19 on page 7, excuse me one moment. On page 7 of their response documents, the RHC responded to a question asking them to, quote, list all settlements entered into by the agency or by the district on behalf of the agency in FY21 and FY22 state. That's an excerpt of the question. And here's an excerpt from their answer. They wrote in their response to you, as a result of the settlement signed on February 1, and just for me to interject, I don't know where that date came from, 2022, the employee has resigned voluntarily and released the district from all potential claims, receiving $400,000 from the district's settlement and judgment fund, inclusive of attorney fees. This statement is, in this end quote, this statement is factually incorrect. I did not resign voluntarily, as the RHC's response inaccurately states. Mr. Spencer terminated me after I filed multiple employment discrimination and retaliation complaints against him. In an addendum signed and dated January 31st, 2022 to my settlement agreement, it states the following. In consideration of the obligations, conditions, and commitments set forth in the agreement, the parties hereby acknowledge and agree that Acosta separated from employment with the Rental Housing Commission effective May 7th, 2020, and that the district's employment records will reflect that the separation was through no fault of her own. And that's the end of this provision shall be incorporated into and considered part of the agreement, end quote. I can't begin to tell you everything that my family and I have struggled and suffered with throughout this horrible nightmare period since I was terminated in May of 2020 by Michael Spencer. The amount of sleepless nights, stress, worry, resulting health issues and financial problems that we have endured due to the loss of my job and employment income, which I needed to support my family, have been almost overwhelming. They say that stress kills, and I'm sure this entire period following my termination will cost me years off of my life and many, many more health problems yet to come. I have been unable to find full-time replacement employment due to the retaliatory charges and allegations made against me by Mr. Spencer, which have not yet been expunged from my DC official personnel record. All this after 18 years of service with the DC government. I would further state that as of February 15th, 2022, no portion of my settlement amount has been paid out yet from the DC government, and I do not have any replacement employment income at this time, nor have I had any full-time employment since Mr. Spencer terminated me on May 7th, 2020. Most importantly, since the loss of my job following Mr. Spencer's termination of my employment, I have not been able to adequately provide for my granddaughter due to the loss of my income. It is very, very hard to explain to a little 7-year-old girl why Nana cannot afford to take her to the movies or buy her toys or go to Chuck E. Cheese anymore. Little children just cannot comprehend when adults experience a financial crisis like losing their job and their source of income. My granddaughter has inadvertently heard me talking about the loss of my job, and she recently asked me if, quote, the bad guy, quote, was going to give me my job back. What could I say to her other than, God will take care of us, don't worry, honey. As I stated, I'm 63 years old now. I have been robbed of my professional career and my source of income to support my family. I had fully intended to work to full retirement age and would never have imagined that I would be looking for a new job to try to make at least a portion of what I was earning with the DC government. However, I never lost my sense of self-respect, my belief in myself, and the firm knowledge that I did nothing wrong to cause this to happen. My ultimate belief was that God would get my family through this, and a very wise man told me to have a little faith and just hang in there a little longer. You see, there's one thing that the universe may have taught us throughout this whole period of the deadly pandemic, civil unrest, social injustice, and political chaos. It's that we need to remember that we are all in this together, no matter how corny and cliche that sounds. We need to treat each other with dignity, respect, kindness, and understanding. And we have to try to forgive people who have hurt us or wronged us. Therefore, I would like to take this opportunity here today to tell Mr. Spencer that my little 7-year-old granddaughter wants you to know that she forgives you for taking away Nana's job. I realize that the only way that I personally can begin to recover from all this would be for me to try to embrace the same spirit of forgiveness as my precious little granddaughter, which may take some time for me to do. In the interim, I sincerely hope that I can walk away from this terrible situation as a better, kinder, stronger person, and somehow apply the skills and strengths that I use to survive to help other individuals, friends, family, future coworkers who may encounter similar life-crushing workplace events in the future. I believe that in light of the serious abuse of managerial power that occurred at the DC Rental Housing Commission, there must be some accountability and safeguards put in place by the council for the future so that no other employees in the DC government ever have to be subjected to the level of unfair and inhumane treatment as I experienced in the workplace at the commission. If the DC council members just turn their heads and look the other way at this point in time without enforcing any consequences for these serious violations of human rights, then you are condoning this type of inappropriate managerial behavior. As a result, similar hostile work environments will continue to emerge in the future, whether they occur again at the DC Rental Housing Commission or at another district or Columbia agency, and other employees will suffer as I have suffered. They say what doesn't kill you makes you stronger, and God does not give you more than you can handle. But you know, I sometimes wish God didn't have so much faith in how much I can handle. I appreciate the committee members taking the time to listen to what I have had to share to you with today. And I thank you for your service to the district, to your constituents, and to your colleagues. I hope that my testimony will help you to proceed honestly and fairly and to just simply do the right thing here. God bless you and stay safe. Thank you very much.
Thank you very much for your testimony, Ms. Acosta. I think we heard from you in great detail as to your concern about the reappointment or the possibility of reappointment of Mr. Spencer to this important commission. And I want it to be very clear. You indicated that the settlement that you entered into would give you remittance of $400,000, of which I believe $100,000 goes to your attorney, and that the separation that you are now in, that it shows there's no fault on your part, and therefore, if it's a settlement, I would assume it also shows no fault on the part of the supervisor. Is that your understanding of the language of the separation agreement?
Sorry about that, council member. She's coming back on.
Okay, thank you.
Councilmember Bonds, can you hear me?
Yes, I can.
I'm sorry, I was removed from being able to hear you. Could you repeat?
I will gladly repeat. I was saying that two conditions of the settlement was one, that you would be paid $400,000, and of the $400,000, I think $100,000 is earmarked for your attorney. The other point is that the settlement finds neither party so-called guilty. Am I correct?
I think that type of question requires a legal conclusion. So if you would like to put that in writing, I can have my attorney address that after the fact. I couldn't opine as to.
Well, you were in the you were in the hearing when I'll say a decree came down. So that is the document that we have before us. That is the document that we have, which is a copy signed by counsel for the defendant, David Branch. So I just wanted to make sure, because there was much information in your testimony this morning. So I wanted to make sure that the public understands that the conclusion of your complaint and really your service with this commission is that you did a settlement agreement where you not only did you sever your employment relationship with the commission, but you also received remittance. And in addition to that, the conclusion was a settlement agreement, not finding fault on either side of the case. That's what we have. So I'll just move on. That's what I have before me.
I really can't opine towards that. I mean, I think there are
Okay.
two different situations. And I will
Okay.
state also that my settlement agreement did not include replacing me in a similarly situated position. So I wasn't completely made whole, and I don't have a job now. So
Well, and that would be a situation that you would have to take up with the court.
I just would make note of that. And
Okay.
I think the facts of the case and the situations involved speak for themselves. The settlement agreement does not change the facts of the case. I don't think any of those points of fact and information were above the realm of the truth.
Okay, well, I can only go by, Ms. Acosta, I can only go by what is the result of this civil action number 2011-89 that we have. So that's what I was responding to. It is in no way to be despairing on what you testified to. I just wanted to make it clear, since you were providing the council members with some guidance, I want you to know what we legally have before us as a conclusion to your situation. So I thank you very much for that. I see Councilmember Silverman. Do you have a question, or would you at this time? I'm not sure where I'm seeing you, but I see you.
Yes, I'm outside the building, Councilmember Bonds. I don't have any questions. I just want to thank Ms. Acosta for her testimony, and I'm sure we'll be asking Mr. Spencer about some of the things that Ms. Acosta testified to. So thank you
All right.
again.
All right, thank you very much. And thank you, Ms. Acosta. And we wish you the very best.
Thank you.
Mhm. We will now turn to Mr. Michael Spencer to provide his testimony, and I'll ask Mr. Spencer if you will raise your right hand. All right. Do you swear and affirm that your testimony and any statements that you make before us today to be truthful and complete?
I do.
All righty. You can begin when you're ready.
Thank you. Good morning, Chairperson Bonds. Good morning, Councilmember Silverman, and members of the Committee on Housing and Executive Administration. I am Michael T. Spencer. Thank you for considering my renomination as Chairperson and Chief Administrative Judge of the DC Rental Housing Commission. I'm excited to come before you today to discuss my desire to serve another term at the Commission. Before I begin, I would like to thank Mayor Bowser for putting forth legislation for my reappointment. Mayor Bowser, who first appointed me to the Commission in July 2016, named me as chairperson in October 2017 and renominated me for a second term in 2018. I am humbled by Mayor Bowser's confidence in my ability to serve our hometown in this capacity. As you've mentioned earlier, Councilmember, the Commission enforces the rental Housing Act of 1985 as amended in 3 ways. We decide appeals brought to the commission from the rent administrator or the Office of Administrative Hearings. We issue, amend, and rescind regulations that implement the act. And we certify and publish the annual adjustment of general applicability to rent, which the commission did last week. And it should be in the DC Register very soon, if not this Thursday. For decades, the commission was an independent quasi-judicial body that was supported by other agencies and charged with enforcing the Rental Housing Act. Pursuant to the Rental Housing Commission Independent Clarification Act of 2017, which Chairperson Bonds introduced, the commission became an independent agency on October 1st, 2019. I've led the commission from an independent body into an independent staff. We've made some major accomplishments. Earlier, Councilmember Silverman mentioned the commission size. We have just 8 nerdy and fun employees. The commission might be the smallest agency in the district government. It is also one of the most important. On December 31st, 2021, the commission published comprehensive regulations implementing the Rental Housing Act of 1985. I'm very proud to say this is the first set of comprehensive regulations. The very first set of regulations were published in 1986, some 35 years ago. This set also includes the first procedural changes ever made to the regulations since 1998. I was a year out of high school at that point. So these are definitely major changes here. These changes will provide much needed clarity on the rules that housing providers, tenants, attorneys, advocates, judges, and litigants are expected to follow in order to effectuate the act. If confirmed, my primary focus will be enhancing the commission's capacity to resolve cases through mediation and decision-making with more speed. The commission's mediation process is designed in commission prior to the day of the hearing, particular case.
Excuse me, Mr. Spencer, you
Yes.
have a very, it says network bandwidth is low. So that is telling us that you're not coming through as clearly as you would like to. And I wonder, do you want to continue trying to do it this way, or do you want to talk to us by phone? Because your testimony is very important. Sophia, did we lose him entirely?
Yes, we did.
Oh my goodness.
Yes, so I think what we should do is wait for him to come back on if he can. Maybe give him a moment to do that. And maybe after, if that doesn't work, we'll kind of, reconfigure.
Okay, thank you. It's crazy.
Oh, it looks like he's here. He's trying to connect to the audio.
Okay, so I thought it was going smoothly, but I guess it wasn't. So I will, I've been advised to just do without video. Is this better so far?
That's a lot better.
Okay, so I'll just start from the top because I assume everyone heard what I was saying. So let's start over.
I'm sorry, just really quickly, Councilmember Bonds, are you there?
Yes,
Okay, great. Okay.
yes, I am. Sorry.
All right, sorry about this. Okay, so I'll start over. All right, first, good morning, Chairperson Bonds and members of the members of the Committee on Housing and Executive Administration. I am Michael T. Spencer. Thank you for considering my nomination as Chairperson and Chief Administrative Judge to the Rental Housing Commission. I'm excited to come before you today to discuss my desire to serve another term on the commission. Before I begin, I would like to thank Mayor Bowser for putting forth legislation for my reappointment. Mayor Bowser, who first appointed me to the commission in July 2016, named me chairperson in October 2017 and renominated me to a second term in 2018. I am humbled by Mayor Bowser's confidence in my ability to serve our hometown as the chairperson and chief administrative judge of the Rental Housing Commission. As you know, the commission enforces the Rental Housing Act of 1985 as amended in 3 ways. We decide appeals brought to the commission from decisions and proceedings before, primarily, the Office of Administrative Hearings, and occasionally before the rent administrator on tenant and housing provider petitions. We issue, amend, and rescind regulations which enforce the Rental Housing Act. And we certify and publish the annual adjustment of general applicability to rent, which the commission recently last week went ahead and published and sent for publication in the DC Register. Just as an FYI, those approved increases can go into effect on May 1st of this year. For decades, the commission was an independent quasi-judicial body that was charged with enforcing the Rental Housing Act of 1985 as amended. Pursuant to the Rental Housing Commission Independence Clarification Act of 2017, which Chairperson Bonds introduced, the commission became an independent agency on October 1st, 2019. I have led the commission from an independent body into an independent agency, and together with staff, we've had some major accomplishments. With just 8 nerdy and fun employees, the commission might be the smallest agency in a district government. It is also one of the most important. On December 31st, 2021, the commission published comprehensive regulations implementing the act. This is the first set of comprehensive regulations since the very first set was published 35 years ago in 1986. And it's the first set of procedural changes since 1998, some 23 years ago. These changes matter. They will provide much needed clarity on the rules that housing providers, tenants, judges, lawyers, litigants, and advocates are expected to follow in order to effectuate the act. If confirmed, my primary focus will be enhancing the commission's capacity to resolve cases through mediation and decision-making with more speed. Our current mediation process is designed to be informal and flexible. In the past, prior to assuming the role as chair, The commission's program was constrained to the day of the hearing in the particular case. This meant the commission did not offer mediation until the parties actually arrived for their scheduled hearing. At that point, the commission, the parties, and their counsel, if any, had invested a significant amount of time preparing for the hearing. If the parties answered that they wanted to try mediation, the commission would end the hearing and allow the parties to meet with the commissioner's mediator. Now, mediation is scheduled for all cases prior to and independently of the commission's hearing. If the mediator recognizes there's a possibility of settlement, the mediator is now allowed to continue to work towards settlement until it has become an effort in futility. The program needs more, though. Chairperson Bond, you recently introduced the Rental Housing Fair Opportunity for Appeal Amendment Act of 2021. Elements of that legislation will authorize the commission to order parties to attend mediation and impose appropriate sanctions for failure to appear as ordered. If I am confirmed and that legislation is enacted, I will work with the commission's brilliant mediator to recruit a pro bono mediation council panel and pro bono mediators modeled after the DC Court of Appeals program. This will enhance the commission's capacity by providing an opportunity for other smart lawyers and mediators to get great pro bono experience while allowing the judges more dedicated time to write decisions and orders for the most complex cases in our docket. As I've previously testified, I spent most of my time as chairman building the commission's infrastructure as an agency, focusing on the first, second, and third notices of proposed rulemaking, the notice of final rulemaking, and other time-consuming administrative matters. That is my past. I'm excited to turn my attention to benchmarking expectations around how fast it should take the commission to issue an opinion in most of our cases. We've recently partnered with the CA's performance management team to assess simple metrics: the average number of days, business days, it takes to issue an order on a procedural motion, and the average number of days between receiving a case and issuing an opinion. As you know, the Act also requires administrative judges on the Rental Housing Commission to be DC residents who are not housing providers or tenants. Further, members must be admitted to practice law before the DC Court of Appeals and possess skills and experience in litigation, administrative law, or housing law. I meet all these requirements. I'm a DC resident. I'm a homeowner in Ward 7's Hillcrest neighborhood. I am not a housing provider or a tenant. I'm admitted to practice law before the DC Court of Appeals. I am in good standing, and I've always been in good standing. I've been a licensed attorney for nearly 16 years and a district employee for a little over 12. I'm a member of the DC Bar. Further, I possess relevant and substantive experience in administrative law and housing law. Over the course of my career, I've ensured compliance with various local, state, and federal laws, including, but not limited to, the Rental Housing Act of 1985, the Fair Housing Act, the Civil Rights of Institutionalized Persons Act, the American with Disabilities Act, the Family and Medical Leave Act, the District Merit Personnel Act, and approximately 24 collective bargaining agreements. Chairperson Bonds, I love my work and I love our city. I'm excited by the idea of continuing my service on the Rental Housing Commission. I have served with competence, and most importantly, I have served with integrity. Again, thank you for this opportunity to appear before this committee today. I am happy to answer any questions.
Thank you, Mr. Spencer, for your statement. I do have questions, and as my colleague indicated, I'm sure she has questions as well. I will start with the questions about the organization of the office and the work that you do, and then we can go into other matters, such as any additional comments you might want to make about the settlement that you have with a former employee, Ms. Acosta. So let's start with, what do you consider to be your major accomplishments as chairman of the Rental Housing Commission? I know you articulated a number of things that are areas of improvement, but what do you consider that is primary in your tenure at the commission?
First, thanks for that question. And before I answer, I just want to note for the record that I do not have a settlement agreement with Ms. Acosta. That agreement is between her, I believe, and the AG's office. The Office of Attorney General is not, I'm not a party to that agreement.
That's correct. That is correct. Yes.
No, I appreciate that. I just want to make sure that's
Mhm.
a record. But first, yeah, that's a great question, council member. And the regulations, I'll tell you the top two for me. I'm gonna say the top three, actually. I think the first is the team at the commission. Let me start there. I came to the commission in 2016. At the time, I started my service with DC government at St. Elizabeth's Hospital, which is the city psych hospital. I started there on February 2nd, 2009. I was probably a little 2.5, 3 years out of law school. And I was recruited by the former CEO, Dr. Patrick Kahneman, to join the hospital. And I was actually recruited to be on the chief nursing executive. I was his and her initially, pretty much senior advisor, senior program analyst. And it was me, I was the only attorney on this 4-person nursing exec team. And while I was there at the hospital, and I'm sure this is no secret to council, hospitals are hard places to work. It's 24 hours. It's like running a city. And while I was there, I did a lot of work with making sure the hospital complied with a settlement agreement between DC and the Department of Justice over alleged patient abuses. And I learned a lot about leadership. Let me be clear too. I was a leader when I came to the hospital, but I learned a lot about leadership. I learned a lot about managing within the district government, a lot about the personnel manual, a lot about working in a unionized environment. And so when I got to the commission, I came to the commission with those skills. And in fact, when I first got to the commission, the former chairperson, within months of my arrival, asked me to be his senior assistant and sort of the office lead on personnel matters, because that was not in his wheelhouse, and he had his own issues trying to manage situations there. And so once I became chair, I had the pleasure of leading a team of, in large part, mostly lawyers, right? And a small team, but just leading a team of people who I think are so passionate about serving the city. A team of people who, because we're small, they're very nimble. And I think the work culture that we've built together is a work culture that values accountability. It's a work culture where I'm pretty sure most of my employees, if not all of them, actually probably all of my employees love, that values autonomy, right? Appropriate autonomy. A work culture that values fun and that values productivity as well. And so I think the most important accomplishment was I do feel like we have a team of people at the commission where I go to sleep at night knowing that people are doing what we need to do to move cases, to do a historic job in doing regulations, to build a culture where people are held accountable, where people want to come to work and do a good job. The second thing, of course, and with the people too, let me also be clear, with the people is right-sizing the organization, right? So we have people like Daniel Mayer, who I've testified on record before, and this is no secret to Dan, who I just admire his brilliance, his tenacity, his work ethic, right? But he wasn't in the position that he should have been in. You know, LaTanya Miles, the clerk of the court, she wasn't getting paid what she deserved. We had Dorothy Greer, who was a de facto mediator who deserves to actually hold the title of mediator. We have Ms. Alim Musawir, who is for years, the district was paying a contractor more than it would cost for her to be an employee to help with clerical matters around an office. And she was a contractor for years. And, you know, I think maybe last year, just successfully completed her first year probation as a DC employee, right? And getting on a path to the middle class. And so major
Mr. Spencer,
I'm gonna move on.
Okay,
I'm gonna go to the next
I hate
piece.
to, well,
That was the
you know,
end.
my original question was, you know, what do you consider to be your major accomplishment? And I think that you really satisfied, you know, sufficient answer for that. And I thank you very much. And it's very clear that building a team at the commission and right sizing the office is very, very important. And I thank you for that. I just want to, at least in this round, have an opportunity to just discuss one other area with you.
Please.
And then I'm sure my colleague would like to ask a few questions. And I appreciate that. And I really hate to interject while you're responding. Okay. Can you please talk to us about this caseload, because you indicated you right-sized the office. You focused on building a team at the commission. And so my question is that the caseload seems very light at the commission. And in light of that reality, I have to ask, do you expect the caseload to increase? And given that you take close to 1 year to make a decision, how is that going to affect productivity if it's necessary, and I do believe it's necessary, that cases be decided much sooner? And I'm not speaking of 6 months instead of 12 months. What do you have to say about that?
It'll be helpful to hear when you say you aren't speaking of 6 instead of 12. It'll be helpful to hear what do you
I'm not speaking of any time. It just seems to me that if the mandate is to make a decision in 45 days, and you have acknowledged that it sometimes takes close to a year, I am saying, well, let's not talk about 6 months. Let's talk about between 45 and 6 months, you know? That's where I'm coming from.
No, I get it. So let me say this again,
but I am, remember, I'm just an ordinary citizen out here. I am not a member of the commission. I do not know the integral parts of the working of your office. And so you are before us as the expert. So you have to provide us with what the real time is and how you see having the ability to expedite cases, and particularly when you have so few cases.
Yeah, so I'm glad you framed it that way. So I will use this as an opportunity to sort of enlighten folks.
Yes, and
Because
Mr. Spencer, please do this for us.
I will, because
Take a breath, take a breath,
all right, let's
calm
go,
down.
DC.
We're trying to get through this. We can't really see you. So just, relax and let's just get through responding to the questions and giving us a true impression of who you are and how you get your work done, because that's what's important before the committee today.
Perfect. So I will do
Okay.
that. Thank you. So to start, in fiscal year 21, it took the commission from the hearing date to a decision, on average, 120 days to issue a decision. And just to give people, who may be listening in, or folks who may watch this later, just a little insight on what we do and how we function. The commission functions as an appellate court. So it functions as an appellate court. Appellate courts generally sit, they have several judges, and they sit typically in panels of three, right? The commission, we have 3 judges, and we sit typically as a panel of 3, unless a COVID emergency, at minimum a panel of 2. We hear decisions that a judge has already made from the Office of Administrative Hearings. So parties have gone before a judge, sort of like if you've gone to court and had a trial and you want to appeal what the judge said. And so what we do is we hear cases de novo, is the legal term. The basic term is we see the case as brand new, okay? We don't establish facts. Like the judge before had already said, hey, here are the facts of the case. We look at the facts, we look at the record, we look at the law, and we say, okay, we basically review the judge's work, okay? Now, a case can be downstairs at OEH, it's in our building. They can have a 4-day hearing on a case. There could be, I don't know if you've seen, the boxes that Xerox paper comes in. We can get 4 boxes, or the digital equivalent of 4 boxes of records that the judge and the lawyer has to look at. So we have to look at every piece of documentation that's in those 4 boxes. We have to listen to the 4 days or 2 days or half a day of the hearing. We then have to do legal research using LexisNexis, look at the database, so to see, okay, do we have cases on that speak to this issue? How do we, again, look at this issue anew, these facts anew? How do we apply the law? Did the judge apply the law correctly? Now, let's say there are 4 issues on appeal, okay? And we said, okay, the judge, she was on point for 3 of those issues, but one of them, she didn't correctly apply the law. We have to send that back downstairs. There are also situations, not many, but enough, where we've done a research of the 4 boxes, we've done a legal research. We then say, all right, let's listen to the 4 days of hearings. And we listen to the hearings and we get what you got earlier when I thought you were hearing me, which is nothing. And so then it's like, oh, we have to send this back downstairs and you have to have a hearing on this issue. And so I think that, that's a sort of a window into our world. In some of these cases, again, like we could get some cases that are really simple issues, may not take as long at all to do. Some cases take longer. And I think this 45-day rule, and I've spoken about this before, I believe at past oversight hearings. I think the genesis of that 45-day rule was a Six Sigma initiative that some folks years ago at DCRA undertook with the commission. I think that's when they supported the commission. And these non-lawyers and non-judges decided that, oh, it should take 45 days. I think that was some way codified. And it's just not realistic, right? And so one of the things that, like, I think the commission has failed to do is to sort of establish what is realistic. One of the things we introduced before was data from the National Center of State Appellate Courts on how long decisions typically take when parties have a right to appeal. And that's where I believe Councilmember Silverman, or maybe you, that's where we see for 75% of cases, the National Center of State Courts, appellate courts said 75% of cases should be resolved in 390 days and 400 and something days for 95% of cases. And so, of course, we don't want that for us. And the housing providers and the tenants and just the taxpayers, everyone deserves, more definitive numbers. And that's what we're working on. So this January 6th, again, I worked with the CA's office to look at our metrics to say, hey, the metrics that we tried to do was way too ambitious and too complicated. And so let us really sit down and think about, and it's also, the metrics also just takes, a lot of time to collect the data we're trying to collect. And so let's sit down and really simplify what we're collecting. So we tell, not only do we tell council, but we tell the taxpayers, we tell the citizens, we figure out ourselves what is the right numbers. And so on January 6th, we started using a new form that the mediator uses and that the judges use. That's almost akin to billing hours, where you basically track your time as you go to get a sense of real life data of where we are. And so that will be my main focus, is really benchmarking what that data is. Yeah.
Okay, thank you very much. So I've learned that you see your work as reviewing the judicial decisions for completeness or for completion and compliance with the DC rental housing law of 1985. Is that correct?
Yes.
Okay.
Yes.
All righty. Okay, thank you very much. Councilwoman Silverman, give you a round.
Thank you, Councilmember Bonds. I just need 1 second because I'm toggling between two meetings. So hang on.
Okay,
Let me leave that meeting. So I have only audio for this. Okay, terrific. So I have been trying to listen in, and I appreciate your testimony, Mr. Spencer. So first, let me just ask, your responses to the committee state that you have, quote, nurtured a toxic-free work environment that encourages accountability, autonomy, competence, and fun. Those are good goals. So can you tell me what steps you've taken to create that type of environment?
Yes, I can. So the commission, we're a pretty small office. We regularly have, I don't know, like social gatherings, like I am probably known for putting on an additional 15 pounds to most employees by just stopping at Whole Foods in the morning and getting cakes and the like. We have regular staff meetings where we talk I think people feel very comfortable putting forth suggestions and ideas for improvement. You know, one of the things, even as far as autonomy too, you know, if a person has an idea that they want to implement or at least pilot, like I've pretty much, I'm open to that. Yeah. And a part of it too, council member, I'll be frank, is my employees also, you know, especially, you know, for instance, like Latanya Mouse has been at the commission for 20 years. And I think in her opinion, she said, I've been the best chair that they've had. And I think other employees feel the same way.
Mr. Spencer, I said in my opening statement that I think part of the benefit of this hearing is giving you a chance to have due process and for you to address Ms. Acosta's testimony. So she had quite lengthy testimony, quite emotional testimony. So I want to give you a chance to address it.
Yeah, well, thank you for that opportunity, Councilmember. When we spoke earlier, I informed you that, again, my philosophy is I don't think a public hearing is an appropriate place to discuss personnel matters. But what I will do is I'm happy to talk about how I carry myself and how I ensure that I adhere to all the expectations of me as not only a agency lead, but just as a DC employee, right? Like, again, like, and it's on my resume, I was literally a labor and employee relations specialist for years with the Department of Behavioral Health. And so I have relationships with people throughout the city who were either attorneys that dealt with labor issues for the district, or attorneys who weren't practicing, but were also labor and employee relations specialists throughout the district. I have trained dozens of managers on compliance with the DC personnel manual. I have, you know, if an employee has come to me or expressed any concerns around whether it's interest in FMLA, whether it's interest in paid family leave, which I myself have taken when I had fostered kids in the system. I have referred people to the Office of Disability Rights. I've worked with Jessica Hunt there. I've worked with the director in the office for employees. I have, when employees have mentioned, just over the course of my career, but if an employee's mentioned having a disability or needing an accommodation, I've proactively referred them to the office. I've told the office all the ways in which I'm willing to accommodate any employee, not only because is it my legal obligation, but anyone who knows me, that's just the kind of person that I am. Like, I'm not a person who, if anyone's even made an inkling that they felt uncomfortable by me, I have suggested in writing, you can go to the Office of Human Rights. I have self-reported matters to the Office of Human Rights. I have let employees know you have a right to talk to any EEO officer within the city based on DC policy. And so, again,
may I interrupt,
yes.
Mr. Spencer, just because we're on a clock? Let me ask the question this way. The case has been settled. And I think, as Councilmember Bond said, the settlement agreement might say that, you know, there is not an admittance of guilt of either party. But now that the case has been settled, do you think you should have handled Ms. Acosta's employment differently in any way?
Again, Councilman, with all due respect, I do not want to discuss anyone's particular personnel matter, but I will say this, just in general. Again, I have, and just to give some background too, you know, as personnel authority, I can serve as the proposing official and the deciding official. What I cannot do is serve as the hearing officer, who is an independent attorney in the District of Columbia that does not work for me, that is not affiliated with me in any way, who reviews every piece of supporting evidence one has for disciplinary action, including responses, and writes an independent recommendation whether a person should or should not, let me rephrase that, whether there's enough evidence to support or not support a termination. And so
I'm going to take
again,
another stab at this. So let us put the individual case aside. How would you, or are there any things you would do differently now, and just in general, as the personnel authority of the Rental Housing Commission? Have you changed any of your practices recently?
well, I haven't had to change any practice recently because I haven't had to do anything recently.
Okay.
I've reported that again, that I'm sorry. I'll let it's a delivery. I'm mute. I'm
Okay.
sorry about that.
That's okay. That's okay. These things happen in our new workplaces.
Yeah, I'm sorry.
But I think my point, Mr. Spencer, is, you know, I will just say I'm a manager myself, and you have certain things happen, and you know, I'm a believer in continuous improvement. So you have certain HR, human resources issues that come up, and I will admit, you know, sometimes a case will inform me to change, you know, my approach, you know, that I learned from it, and I say, I can handle that better, differently next time. And what I'm just asking is there anything you feel you've learned from this that then will inform how you would deal with, like, let's say a paid family and medical leave request the next time?
Yeah. So first, I haven't. I'll say this. I agree. Like, I definitely am a person who has room for continuous improvement. Okay. I will talk to my well, if reappointed, I will talk to the GC, and hopefully also engage with the numerous attorneys from the Office of Attorney General's office who worked on cases concerning Rental Housing Commission employees in court dating back to 2012, well before my tenure at the commission. But I would talk to them and really see, like, hey, what could I have done? Like, what should I have done differently? Right.
Right.
Like, yeah, like yes, make no mistake. Like, I am not sitting here as if I'm a perfect human and I have no room for growth. Right. Like, in fact, not because related to this situation, but on my own last year, I spent $5,000 in executive coaching. Right. And so I am definitely a person who believes in, I mean, I went to school for a long time, but I definitely believe in, like, lifelong learning. And
I do too.
I'm definitely happy to sit with the AG's office. And because, again, these are folks who, they're going to have a different lens than I have, right? And they'll be able to inform me of, hey, this is where you should have done this differently. And so, and as far as the FMLA piece, I don't handle FMLA at all. So legally, I can't, as a supervisor, review an employee's FMLA. At any FMLA that would have been handled would have been at like we handled through before we became independent. So I'm not a part of FMLA reviews or decisions whatsoever.
I know I'm over time, Councilmember Bonds, but can I just ask one follow-up to that, which you might be curious about too? So who handles either FM, so for those who are non-acronym friendly like myself, a family, unpaid family medical leave or a paid family medical leave, then who handles that now that you're an independent agency? I would assume you would as the supervisor and personnel director.
No.
Are you telling me you wouldn't?
No, I'm telling you that I cannot by law, right?
Oh, okay.
So by
So-
law, and this is, but who will
Okay.
handle is this? It will, the liaison in our office for, so depending what it is, right? So for ADA cases, we created a relationship with the Office of Disability Rights. So if a person wanted an accommodation, we referred that individual, any individuals, to say, hey, go to ODR. They're going to process this. ODR will send messages saying, we've been asked to process any ADA requests come through us. For FMLA and paid family leave, an employee could start with Daniel Mayer, who is, again, one of the most brilliant lawyers in DC, who is our GC, is the commission's GC. They will start with Daniel. Daniel would then work with DCHR to process that. And they will work with payroll to make sure that the person's PeopleSoft system was populated to accept that. So I'm not the person at all.
Got it. Thank you, Councilmember Bonds. I appreciate your lenience there.
Thank you very much, because these are questions that, and answers, more importantly, that will help us understand not only how the office works, but how we may have reached the situation that was described by Ms. Acosta or any other employee for that matter. So thank you very much for that. I do have, I'll just do now a follow-up as it relates to Ms. Acosta's testimony. She indicated that there were some 800 emails which spoke to the type of service or classified the services she was giving or not giving in the office. And so I guess, Mr. Spencer, to me, 800 sounds like a lot, given that you probably did not usually correspond with all of your employees on a daily basis. So can you comment on that? Is that something, is that your way of saying, hello, let's do this? Or please explain 800 emails.
So I'll say this again, when I was speaking to a specific case, I will say, if I sent an employee 800 emails, I was likely replying to 800 emails that I received, or I was documenting something that an employee said that I thought was problematic and needed to be documented in writing. So most employees at the Rental Housing Commission will tell you that they have not received 800 emails from me. On an average week, they probably don't receive 2 emails from me. On an average month, they may not even receive 3 emails from me. So like that, I'm not a, I am not an emailer or a caller. I am, again, like, I believe in autonomy. I believe we're all professionals, we're all adults. And so, no, that's not a norm. But again, just through my practice and employee relations, which dates back to 2009, again, in the district, and again, working and with plenty of different types of employees, right? And being involved as an advisor to managers on how to handle hundreds of employee relations matters. Sometimes I found the best practice is to document. And again, for the most part, if I sent an email, it was in response to an email that I received.
All right, well, thank you. I thank you very much for that. I have a couple of other questions. Let's talk about the bread and butter of your agency, and that is, let's talk about determining CPI. Can you describe the process that the commission uses or to establish the allowable rent increase under the Rental Housing Act in calendar year 2022? And what do you expect that increase to be?
So yeah, so I'll start with the meat of that question, which is what is the increase? All right, so it's breaking news for everyone who's listening in. So the rent adjustment that goes into effect on May 1st, if any adjustment whatsoever, because a housing provider does not have to adjust rent, but if they do, generally speaking, it shall not exceed 6.2% of the current rent. For people who are elderly or tenants with disabilities, effective May 1st, it shall not exceed 4.2% of the rent, the current rent that's being charged on April 30th. I'm sorry. So whatever your rent is charged on April 30th, if you are elderly or disabled tenant, it should not exceed a 4.2% increase. And, and again, the housing provider could say, I'm not increasing rent, I'm increasing it 1%. But the housing provider, if you're elderly or disabled, cannot increase it more than 4.2%. And again, if you're not elderly or disabled, generally it is a 6.2% increase. Of course, that's unless there's any special approvals, like, a capital improvement or something that, or, hardship petition. But those are, very rare cases right now. The way we determine it is there's a calculation where we basically look at the, sort of like economics, I guess, but we look at the Washington, D.C. Standard Metro Statistical Area CPI, Consumer Price Index. And we take that index and we are able to add, generally speaking, 2% to that figure. And so we have a 5-page notice that we just published. It's available on our website at www.rhc.dc.gov. And it'll also be in the DC Register as well. And this goes into effect May 1st. We were legally required to publish it by March 1st, but we were able to get it out soon this year. So we wanted folks to know as soon as possible.
All right, well, thank you for that. Can you explain what a hardship petition is and why does it allow a 12% increase in rents? Isn't that a bit high, given that it was set in the 80s when I think the interest rate then was around 11, 12%? Because this really guarantees to a owner of a property, rental property, that they will or can see at least a 12% profit.
Yeah, so, I want to be clear for everyone listening, because, this is also, like you mentioned earlier, Councilmember, this is an opportunity for a lot of folks to be educated on not only the commission, but the act. And so as far as is 12% a lot? I am, my hope is that I'm reconfirmed, but I am up for nomination to again be the chief administrative judge. Just as a judicial matter, we don't comment on policy matters of this point. The reason that it's 12% is that's what the law that the legislative body passed, a 12% increase. And we explain it, and what we can do too, council member, because again, I do want us to educate, and I think sometimes, you know, it can seem quite elite where you just sort of like, people think you hide behind, oh, I'm a judge and I'm not going to discuss this. But what we'll do, and if you give me until, this is what we'll do. By March 1st, we'll just publish some easy to read one-pagers on our website, and we'll send them to this committee as well. Well, let me say this. I will relate to the commission, because I may not be confirmed, but I will relate to the commission an idea about them publishing some one-pagers on just the different tools that could be used for rent increases, because it is important and probably timely for folks to sort of think about what does, you know, with us having new regulations, what does the regulation say about these special improvements? So as they think about potential rent increases that they may face May 1st, they'll also know what these other approvals are in case that increase does exceed 6.2%. Does that work
Okay.
for you?
It does, but what I really was hoping that it would be helpful to have a sense from you, your thinking about these devices or tools, as you call them, that really add on to the rent that a tenant must pay, or is by law obligated to pay. And just wanted to explore, when we talk about rent in the District of Columbia, not anyone, even those persons who are in market rate, are comfortable. And of course, I don't know what our authority can be as it relates to market rate units, but we are slowly but surely seeing continuous ticking up of the cost of housing in the city. And that is a big concern, neighborhood to neighborhood, and certainly for those of us at the council, because we don't want our laws in any way to push our people out simply because, of the price. We want our people, our residents, to be able to stay and thrive in the city. And so, you reach a point where the cost of living is just exorbitant, and you just can't make it. I mean, across the nation, that's part of the discussion about, cost of living, and housing is a big part of your cost of living. So it was really just to get some feedback from you, not to tread on what your official role is at the commission and how you have to deliberate on individual cases, but just to generally have a chat with you about, this aspect, the high cost of living, and how the commission can looks at the high cost of living.
Yeah, I think the way we see it, because again, like we all love DC. Let me just keep it clear, like we love DC, and we're not blind to the housing instability that a lot of our neighbors face and some of our family members face, right? Like we see it. What we see our job is, how do we do what we do as best as we can, right? And so even getting back to Councilmember Silverman's question as far as like, learning and improvement, it's like, how do we do this better, right? Like, how do we, and I think that's what in some ways the regs are going to do, like my hope for regs is like, how do we do this so there's so much clarity around what the rules are, right? So we're able to calm folks' stress a little bit more because they can go to a rule and one of my goals for the year would be to also publish just really easy, simple to read, like, hey, I can understand this without a law degree, because a lot of times it's hard for us to understand it with a law degree too. But like, hey, here are the rules, right? Here's this one-page guidance that, like, yes, you can do this if I'm a tenant, or yes, I can do this if I'm a landlord, because here's a quick sheet. And so I'm not digging through 200 pages of hard to read, and they're easy to read now, but I'm still not digging through 200 pages of regulations to find a simple answer. So I think that's how we help the city, and we help residents and housing providers, is by just making sure that we're as clear and transparent as possible about what we do, what we can do, and what we know, right?
All right, so am I hearing that one of the goals of your office is to create almost like a little hot sheet of information that, in a nutshell, will explain to tenants as they may have a particular issue, such as, the hardship? I'll continue to use that as an example. A hardship petition from their landlord, indirectly coming, well, really it comes to the government entities. Just wondered, am I hearing that you're going to produce something that's easy for tenants, for the public to understand, so that they do not have to go through 600 pages?
So let me be clear. They may have to go through just 200 pages for certain things, but on hot topic issues, we will issue that. Since we haven't had any hardship petition cases at the commission recently anyway, but we want to create the hot sheet, right? Like, just something easy. You go there, you print it out, it makes sense to you, with real life examples, right? Like, hey, I'm elderly and my rent went up 4.2%. Like, what does that look like? What does that feel like? Using numbers that people can relate to.
That would be great, and that would be very helpful to the community. For a second round, Councilmember Silverman.
Thank you, Councilmember Bonds. Mr. Spencer, I want to switch gears in this round to the commission's operations and its main mission. So I think the answers to committee questions just went online, and there's some good news here.
Look at you smiling.
Well, I'm here, and I think Councilmember Bonds is here. We're here to make this government work better for our residents.
Mm-hmm.
Yep.
I'll just be as I've told my staff, and I was just on a call with the Workforce Investment Council. I'm done with I'm just who I am. So when there's something good to highlight, I'm going to highlight it. When there's something troubling, I'm going to highlight that too. This is good. That's why I'm smiling. This is what oversight is supposed to do. We asked you tough questions. Councilmember Bonds asked you tough questions. The Housing Committee asked tough questions about the timeline of coming to decisions last year. And you know what? Oversight worked. It looks like there's improvement. That makes me smile. It does, because otherwise it's like banging your head against the wall. Mm-hmm. That's just my commentary, perhaps for bigger dysfunctions in our government, but let's talk about what we should be happy about here. Okay, so I see that the average hearing to decision timeline went from 344 days in fiscal year 20 to 120 days in fiscal year 21. That's great. I'd still like to get it lower, but look, that's a difference of, if I'm doing my math right, 224 days, which is like 2/3 of a year. Mm-hmm. So that's a big deal. So the responses describe that new procedures played a big part in this condensing of time. So can you describe to me how you and other commission staff, can you describe what these changes are, number one, how you came up with them, and then, how they were implemented? Was this something that you came up with? Is it something that you came up with collectively, or is someone else on your team deserve the credit here? Like, how did this happen?
Yeah, so largely everything we do is collective, right? Like, I think that's the beauty of when I talk about autonomy. Like, I talk about people like Daniel Mayer or Latanya Miles, or Dorothy Greer, just saying, hey, I worked on this case that I knew we needed to get out, right? And so, one of the big pieces is strengthening our mediation program. Like, to me, it's a no cost way to resolve cases. Because while we are happy to work on every case that comes to us, sometimes people, and we're obligated and happy to look at every issue, like literally research every issue the person brings and write about it. But sometimes people bring issues with 120 issues in there. We have to sit and, that sidelines a judge's ability to work on another case until that's resolved. And so when we're able to rely on mediation, it definitely helps our numbers. When we're able to, give parties sometimes a chance to sort of think about if they want to resolve their matters outside of us, that helps. Another part too is just sort of like us being more focused on production, right? It's this past year, we haven't had to spend much time other than, I'll work with outside offices. We haven't had to spend much time on a lot of the administrative matters that we did when we first became independent, right? Like, it's a lot negotiating contracts with other government agencies in the whole 9 yards. And so it's definitely a collaborative effort. And it makes me happy to see you smile. I definitely do not deserve all the credit whatsoever. But what makes me even more excited is just like, I think our future is a lot brighter, to be honest. Like, I sort of feel like, particularly with the Rex done, it's like, oh yeah, we get to just be geeks again and sit with cases, right? And yeah. So it's exciting.
I know that I think there's a performance oversight hearing tomorrow, and I hope this will be covered in more detail in it. I'm not going to be able to be part of it because I have I'm chairing my own hearing. So sorry, Councilmember Bonds, about that scheduling snafu. But let me wrap up by asking you very plainly, Mr. Spencer, there was a $400,000 settlement. And that raises questions. And as I said, red flags for council members. So why should you be reappointed, in your own words? How do Councilmember Bonds and I talk to colleagues about this settlement? Because not everyone's a member of this committee and has the opportunity to hear your answer, and they might see this settlement and be concerned. So help us address the concerns that our colleagues will have about this and your management of the agency.
Yeah, thank you for this opportunity too. I really appreciate this. So first, my record as an employee, particularly as a district employee, has been great. All right, my record's been great. And I will put my record up against anyone else's record. Okay. And so I think if council looks at the performance oversight responses, at least dating back to 2017, I've been very transparent about any staff issues that have taken place at the Rental Housing Commission. I have also been very open, right? Like, and my staff has continuously said they're happy to talk about their experience working with me and working with other colleagues at the commission, and their histories prior to me joining the commission with colleagues at the commission as well. I'm also just, I'm a stand-up person, like beyond my work, right? Like, to be very transparent, you know, it's no one likes their character question. No one likes their integrity question. You know, yeah, my grandfather passed away this January, and we buried him. And I think 2 days later is when I spoke to you, council member. And so it was very difficult to have a conversation about things that I know are not only false, but things that for me personally, and being very transparent, harken back to some of the ugliest times in this country, right? That to me, where I know the truth and I see things that are, you know, are being alleged and quickly withdrawn, and then alleged again and quickly withdrawn, you know, and I know the danger of that, you know, and I think about my grandfather who helped raise me in Acosta, gave me work ethic, told me how to be respectful, gave me confidence that a lot of people sometimes, you know, unfortunately, with a Black man doesn't know how to handle, right? Who taught me lessons about Emmett Till and Caroline Bryant. And so it's like, look at me, like I'm a person who, and I'm honored to be here. I'm honored to answer this question, but it's also, again, a person who I've worked very hard my entire life. I've worked very hard in the city. I've been, you know, on boards far and wide. I have been entrusted by this city to raise the Rudd boys after the disappearance of their sister. And so when someone throws allegations around that they know aren't true, it's very troubling for me. And so what I say do is do your due diligence, right? Like, as you're doing today, if folks want to have a conversation with me off the record, I'm more than willing to talk about whatever they may need answered. Again, I'm thankful for the mayor's confidence in my nomination, and I hope that I have your confidence as well.
Thank you for that answer, and thank you, Councilmember Bonds.
Mm-hmm. And thank you for your question, Councilwoman Silverman. And to Mr. Spencer, I appreciate very much hearing about your character, because you really described it more than adequately, and about your integrity, accessibility, transparency, your competence. You know, what I really think is also a part of the answer to that question is, what is the value that you bring to the office? Because ultimately the decisions that we make are based on what does the government and the people of the District of Columbia get by having you serve in this capacity.
Yeah, thank you. They get competent leadership, they get humble leadership, and more importantly, they get results, right? Like, look at the fact that these regulations weren't done since I was 6 years old, and I'll be 43 in a few weeks. Like, that's crazy. That's crazy. And again, I didn't do this by myself, right? A lot of this goes to past commissioners, the past chair, current staff, Daniel Mayer for sure, right? Judge Gregory, Judge Ruparanga, like, this credit goes around. But the fact is, I led this through, right? The same way we look at these reductions in numbers, I led that through. The same way we saw a commission change from a body to a fully functioning independent agency, I'll let that through. And so what you're going to get is reliable leadership that, through my record of 12 years in district service, has never credibly been attacked. And I want to be very clear, credibly been attacked. And so to me, like, that's what you're going to get. You're going to get somebody who, my employees love their jobs. My employees are happy. My employees are properly paid. They're properly supported. They have development opportunities. And also, you may laugh at this, but you also don't get any drama. Like, I'm a no drama dude, right? And so, Councilmember, I said no drama. You don't get any real drama with me. And so I think, and again, stakeholders have been satisfied, right? Like, they've testified before. They've testified about the way I was leading commission, the way I was engaging stakeholders in conversations and making things transparent. And so I think that's the value that I bring. And it's been the honor of a lifetime to do this work, to like answer hard questions, not only today, but just legally, right? As we're going through cases, you think about decisions we've made that have clarified things. You look at the Feynman case. For years since council abolished rent ceilings, people didn't know what the law was. And we figured it out, and we did the hard work. And the work was so, in a humble way, it was so good that council codified it, right? And so that's what you're going to get. You're going to get clarity, and you're going to get, you aren't going to get us to delve into spaces that we don't belong in, but in the law, you're going to get clarity. You're going to get regulations that are timely implemented, and you're going to have clarity around what the rent increases should be. And you're going to have folks be held accountable, right? Yeah.
I appreciate that comment. And it caused me to reflect back on my office, me having the opportunity to finally define rent in this great city of ours. For so many years, the terminology and the numbers were just floating around in stratosphere. And to finally do that, I do believe it was historic for our tenants in the city. So thank you for remembering that and triggering my memory. Thank you on that. I do have just couple of other questions as it relates to the work of the office. Can you describe the significance of the final rulemaking, which took effect on the 31st of 2021?
Yes, I literally just sort of jumped up off camera, but yes, I guess I could definitely talk about the significance of that. It matters because people are going to know what the law is, right? I think for a long time, and not throw my profession under the bus, but like a lot of times lawyers, whether you're advocating for a housing provider or a tenant, you use the lack of clarity to try to create law, to try to advocate for the creation of law through, a decision. And so that's no longer necessary. So you think Councilmember Silverman talking about banging her head against the wall, right? Like, you all spent all those years, 20 years, implementing new law, amending the Rental Housing Act. But if I'm a regular person looking at a regulation, for 20 years of that work was not accounted for. And so now it's accounted for, and we definitely have an incentive and the obligation, but also an incentive to move faster. So every time that something comes out, within 45 days, our goal is to get out a notice to the public on what our intentions are regarding that piece of legislation, right? Whether we need to amend the rule or create a rule or rescind the rule based on the legislation. And so you get clarity. And the part of it too, not that I'm passionate about this piece, the judges below and OEH, who are super smart and super busy, they get clarity. So they aren't trying to figure out this nuanced piece of law that we haven't, as a commission, made clear to them. And so they're just, figuring out, well, I gotta make some decision based on what I have. And what I have is from 1985. So let me figure it out myself. And so I think that's the significance, is that, I mean, the law is a beautiful thing, and it's now, as far as the Housing Act is, it's clear. And so it's major.
Thank you for that. And on the Rental Housing Fair Opportunity for Appeal Amendment Act of 2021, that's Bill 24-461. I'm sure you're familiar with the legislation.
Yes.
Okay. Why is it important for the commission?
Well, so I'll talk about, elements, as I mentioned in my testimony. Elements of that is super important to the commission. In part, if the commission, okay, so right now the commission doesn't have authority, secret out of the bag. We don't have authority to order anyone to mediation, right? And so when I say that, I mean, we schedule everyone for mediation now, but we have no enforcement powers. We have no ability to say you have a legal obligation to show up in good faith. You have an obligation to show up with settlement authority so no one's time is wasted. This will give us that opportunity to say, hey, you're going to mediation and you're going to behave yourself while you're there. It also gives us a chance because right now we don't have the authority, and if we were challenged on it, I think attorneys could win. But it also gives us the chance to really build our capacity at no additional, at least at a nominal cost, if any, to the public, because then we're able to say, not only do we have a mediation program with our amazing mediator, Dorothy Greer, but we could create a volunteer opportunities for other folks who want to come in and figure this out, right? And help us resolve some of these cases that are really just low-hanging fruit that could easily be settled a lot sooner if we had more help. The last part of the bill that I want to speak to is it provides fairness to parties. Typically, a party has 30 days to file an appeal. Under the act right now, you have 10 days. I had the honor early in my time at the commission of also writing a decision that was pretty groundbreaking in a quieter way. And so before, it was, if you filed after that 10-day deadline, you didn't have a case with us. It was just like, all right, sorry, unless it was like, I was in the hospital with an asthma attack or something crazy. Like, you didn't have a case. But I looked at Supreme Court decisions and said, well, actually, that's not true. You do have a case because this rule is flexible and we still have jurisdiction. And so what this act will do is provide parity, equality with what folks have when they go to the Office of Administrative Hearings, 30 days. When you go from Superior Court or from us to Court of Appeals, 30 days. And so it gives parties, landlords and tenants more time to say, hey, let me evaluate whether I have a case to appeal. Let me figure out if I have time to consult with an attorney before I file an appeal. Let me write a notice of appeal that's actually sensible, right? And so I think that's what the elements that excite us most will actually accomplish.
Thank you very much, Mr. Spencer, for your testimony and for being responsive to our questions today. And so I'll say this concludes today's roundtable. Thanks to you and to those who have watched our proceedings today. Thanks to my colleague who took time to join us. And thanks for giving us your picture. We see you now. The public record for this matter will remain open until the close of business on Friday, the 18th of February, 2022. Any member of the public who wishes to submit written comments on this confirmation should please do so by the close of business on Friday, the 18th of February. The next meeting of the Committee on Housing and Executive Administration will be tomorrow, February 17th, 2022, and we start at 9:00 a.m. We will be meeting to conduct a performance oversight hearing for the government representatives from the Department on Housing and Community Development, the Housing Production Trust Fund, and of course, the Rental Housing Commission. So, Mr. Spencer, I think with that, I'll say we'll see you tomorrow, and we're looking forward to, I think yes, you're still eligible to present. No, you're not.
Yeah, Dan, you mayor will be there representing for the commission tomorrow.
And what about the, you have another commissioner that is eligible also. I'd like for her to attend as well.
Okay, I'll
All
relay
right.
that information. Make sure she's
Okay.
available.
Thank you very much. And thank
Thank
you
you.
again for your time and attention to this matter. All right.
Thank you. Thank you so much.
Thank you. And with that, I'll indicate the time is now 11:50 a.m. And this roundtable is adjourned. Thank you again.